Hello, my name is Steve Lewicki, and I'm a partner at Lewicki, O'Connor, Hunt & Miser, a full-service law firm in Howard County, Maryland. A limited liability company, or an LLC, can be a great way for a small or mid-sized company to structure their business. It provides asset protection benefits like that of a corporation, but it also allows owners of the company to structure the LLC as a pass-through entity for taxation purposes. Unfortunately, problems sometimes arise when the manager of a limited liability company puts his or her own interest above the interest of the company, or acts in a way inconsistent with the obligations owed to other owners of that company. The Maryland Limited Liability Company Act doesn't expressly describe the fiduciary duties that are owed by managers of an LLC to the company, or the duties owed by each owner of an LLC to co-owners. Instead, Maryland appellate court decisions over the years have established a body of law on the fiduciary duties owed by members and managers to their companies and to fellow owners. Beyond abiding by those common law fiduciary duties, managers and members of a Maryland limited liability company also must adhere to the terms of the company's operating agreement. Maryland law recognizes different types of fiduciary duties. For example, there are fiduciary duties between trustees and beneficiaries of a trust, between corporate directors and corporations, between lawyers and clients, between guardians and wards, between agents and principals, and among partners in a partnership or members of a limited liability company. When it comes to business entities such as corporations, partnerships, and LLCs, the basic obligations revolve around ensuring that corporate officers, managers of limited liability companies, and partners act only in ways that advance the interest of the company and not the individual interest of the corporate officer, LLC manager, or partner. Officers and managers can't take action that conflict with or adverse to the best interest of their company. For many years, there was uncertainty in Maryland law about whether a distinct legal cause of action was available to sue for breach of fiduciary duty. In 2020, however, the Maryland Court of Appeals clarified the law in this area and expressly held that a member or manager of a Maryland LLC can be sued by other members of the company for breach of fiduciary duty as an independent and freestanding cause of action. To sue for an alleged breach of fiduciary duty in Maryland, the complaining party must be able to demonstrate that there is a fiduciary relationship between the person bringing the claim and the defendant, that this fiduciary duty has been breached, and that the complaining party has been harmed by that breach. Now, not every breach of fiduciary duty is legally actionable, and not every breach of a fiduciary duty gives someone a right to sue for monetary damages. Some breaches of fiduciary duty can only be remedied by using a court's equitable powers, such as through the issuance of an injunction by the court ordering the offending party to do something or to cease doing something. It's common for clients to come to me describing situations that call into question whether a manager of a limited liability company may be breaching the fiduciary duties that he or she owes to the other owners of the company. From the company's perspective, it's important to ensure that decisions by company leaders are directed toward the interest of the company and not solely protecting the interest of individual members or officers. From the perspective of members in a limited liability company, I often hear from so-called minority members of the LLC. That would be members that don't control the company because they own less than half of the ownership interest in the company. That the people controlling the company are acting in their own benefit and not in the best interest of the company as a whole. The same complaint can arise in business partnerships. There may be time limitations on asserting any claim, and it can be critical in some situations that injunctive relief be sought without delay. If you have questions or concerns about the fiduciary duties owed by managers of a Maryland limited liability company, our firm would welcome the opportunity to answer your questions and provide legal advice in this area.